Right, so let's have a look at a story that has caused a lot of uproar on different social media platforms, because you will have to part with what you contribute in a marriage should you decide to part ways with your spouse. Now, this is the verdict of the Supreme Court, which in a landmark ruling issued today will now clear the uncertainty around marital property. Judges further resolved that marriage is not a guarantee of getting a 50% share of wealth after divorce. Gloria Milimo with that landmark ruling.
In a ruling that is now likely to elicit mixed reactions among married couples whose union has hit rough waters and divorce remains the only option on the table, couples who opt to divorce will now have to prove contribution to the marriage, whether monetary or non-monetary or both, when it comes to sharing of property. The highest court on the land ruled that marriage is not a guarantee for an automatic equal sharing of matrimonial property. It further stated that although the law guarantees equality in marriage, it does not mean that one will get an equal half of wealth generated during the union.
Kama ni mali yake ambaye yeye mwenyewe alinunua, ako right abebe aende nazo na niwachie zangu.
Umefanya kazi sana, ukanunua vitu kwa nyumba, na unapata wakati umewachana na bibi yako anatoroka na mali yako. Sasa ni vizuri sana unaweza kupata jinsi ya kufuata mali yako.
In their ruling, Supreme Court judges said, and I quote, while Article 45, Section 3 deals with equality of the fundamental rights of spouses during and after the dissolution of marriage, we must reiterate that equality does not mean the redistribution of property rights at the dissolution of a marriage, end of quote. The judges said the provision of the article does not guarantee an automatic 50% share by fact of one being married. They further explained that an equal sharing of matrimonial property would encourage men and women to get into marriages as a ticket to wealth. They explained, and I quote, noting the changing times and the norms in our society now, such a finding would encourage some parties to only enter into marriages comfortably subset in the marriage without making any monetary or non-monetary contribution, proceed to have the marriage dissolved, then wait to be automatically given 50% of the marital property. That could not have been the intention of our law on the subject. End of quote.
Hiyo hata mimi wacha ikae hivyo. Juu inaweza kuwa mimi ndio niko na mali mingi hata kushinda huyo bwana.
Meanwhile, Justice Teresa Madeka argued that judicial officers should factor in the 9 months a woman carries a pregnancy. According to the judge, it is unfair to find housewives contributed less or nothing. She pointed out that the society has been able to monetize carrying a baby through surrogacy, adding that taking care of children is a full-time job. She said, and I quote, it is easy for the spouse working away from home and sending money to lay claim to the whole property purchased and developed with that money by the spouse staying at home and taking care of the children and the family. The spouse will be hard to say that the other one was not employed, so they contributed nothing. End of quote.
Haimaanishi kwa sababu sina kazi sijamsaidia. Nimemsaidia kwa sababu nimempatia maarifa, nimempatia ideas, na pia nimemzalia watoto.
The spouse will be hard to say that the other one was not employed, so they contributed nothing. End of quote. She argued that it would be unfair to only rely on seen income and the mindset that one has to contribute money to marriage to find value is so entrenched in the society that housewives are the ones telling the courts that they do not work, simply because they do not leave home to go earn money elsewhere. Similarly, Chief Justice Martha Koome said that a man who cohabits with a woman in a property held in the woman's name also needs to prove contribution that he made. Gloria Milimo, KTN News.
An interesting conversation there based on that story that my colleague Gloria Milimo has filed, bringing us to a conversation with the family lawyer Pauline Mwaniki, joining us virtually. Wakili, good evening and thank you for joining us here on a KTN News tonight. Let me just begin our conversation, from one of the women who was speaking in that story, saying that I'm not employed, I am working at home, taking care of our children, ensuring the house is well kept, food is cooked for my husband. How would you quantify this in terms of trying to divide wealth in case a divorce happens?
All right. Thank you very much. Good evening, and thank you for hosting me. So how I would quantify that is when you look at the Matrimonial Property Act, under Section 2, contribution can be monetary or non-monetary. And contribution includes domestic work and management of the matrimonial home. It includes childcare, it includes companionship, and it includes management of family business or property, and also farm work. So for instance, that lady who has said, I was not working, I was busy taking care of the home, and I gave him children, that can be quantified as a contribution.
But then how do you divide the property? Because clearly you're a housewife. You are not bringing in anything financially. So when it comes to dividing property, how will you do that?
How that will be done, as you have seen with the landmark Supreme Court ruling today, is that it will be case-by-case basis. Because Article 45 of the Constitution, 45.3, provides equal rights before marriage, during marriage, and after marriage. But when it comes to the actual division of the said matrimonial property, now I think it's best that it goes on a case-by-case basis.
Right.
Because there are those who are able to prove that indeed we bought this piece of land, this is the amount of money I contributed. Then there are scenarios where someone is not able to prove that I gave monetary contribution. So that is where the discretion of the judges comes in, so that they are able to analyze based on this situation, what is the share, what is the ratio of sharing of this property.
All right.
So that it means that does not guarantee automatically that it has to be 50-50. So that to save the person from someone who will just come into marriage with just the intention of getting the property. All right. And not working for marriage.
So Akili, let me paint this picture. So you're in your marriage, you're a couple, you put your finances together, you buy your property together, you've contributed in terms of buying a house, a car. So how will you divide this property that both of you have put in finances together?
How it should be divided is, one, let's say for instance, number one, you have to check, is this property registered in both names? Because when it is registered in both names, it makes it easier. Because that means that you are jointly registered on that property. Secondly, if the property is not registered in both names, whether it is registered in the name of the man or the woman, the other spouse has to prove their contribution. So now that is where, if it is monetary, you prove the monetary contribution. If it is not monetary, then you prove the non-monetary contribution, so that now you can get an allocation of a percentage.
All right. And you know, on social media, so many people are saying that this law will actually stop, some ladies or men who want to get into a relationship with someone wealthy in the name of getting property. So in a sad incidence, you get into this relationship, with a man or a woman, and suddenly your partner dies, and you've lived together. You're claiming, I also contributed, I supported him, not materially, but emotionally, in different ways. So how will this person also claim part of that property, owing to the fact that you've come in as probably a second or a third wife?
Okay, so where a spouse dies, now that is where succession law comes into play. So if it's under the Law of Succession Act, Section 29, it defines who a dependent is. A dependent can be a wife or wives, a former wife or former wives, and the children of the deceased. And when you come to children, it can be either children that the deceased was living with or taking care of them or not. Then we go to the second category, where we have the parents, the step-parents, the siblings, and we also have children whom the deceased had taken in as their own, and brothers and sisters, those who are being maintained prior to the death of that person. Then we have the third category. If it was a woman who has passed on, then the husband can be a beneficiary or a dependent if the husband was relying on the woman. So when it comes to such a case, and now the property should be distributed, if you're claiming to be a wife, then you have to prove that you are a wife to this person, so that now you can distribute the property. When it comes to succession, the distribution is different to how it would be in matrimonial property.
All right. Wakili, in a minute, because we need to wind up just in a minute, and she'll give me this response in a minute. So what is your message to Kenyans? Should they be worried about this ruling, or they should not be worried about this ruling?
I think Kenyans should be encouraged because, one, the law is here to protect us. And it is good when you get, what I would advise Kenyans, when you get married, please get married in the right way. And according to the Marriage Act 2014, the proof of marriage is a marriage certificate. So if you go the civil or the Christian church way, get a marriage certificate. If you go the traditional way, you are expected to register your marriage after finishing the customary rites. Yes.
All right. Thank you so much, Pauline Mwaniki, a family lawyer. Thank you for your inputs tonight when it comes to this marital property that the Supreme Court gave a ruling. That issue of 50-50, it would not come automatically. You have to state why, how you actually contributed to that marriage so as to get, part of your share.